Okay, let's go on the record on cause number DC 1916287, Wildwood Natural Corporation versus Shinshan Market. Council, make your appearances.
Good morning, Your Honor. Kapul Chaudhary for plaintiffs Wildwood Natural Corporation and Chancho Park.
And this is Daniel W. Rowland for defendants Shinshan Market and GB Na.
Great, and you guys are here on a motion for continuance, is that correct?
Yes, Your Honor.
Yes.
All right, let's go ahead and proceed.
All right, Your Honor, this is our motion. And first of all, I would just like to remind the court that we've already talked about much of this motion for continuance. We've already dealt a lot with it at our last hearing on plaintiff's motion to quash. Our motion for continuance really had three components, two of which were the motion to quash, the deposition, of Jin-Suk Park and the corporate representative of Wildwood. The other thing we wanted to do was push back the trial deadline. The court's already told the parties to agree on that. We've already sent proposed orders on what we could agree on. We agreed on a February 15th trial date, if that pleases the court, and we've sent agreed orders on that, an agreed scheduling order. And the plaintiffs have agreed at a mutually agreeable time. They're about to give us deposition dates for both the corporate representative Wildwood and Jin-Suk Park. So we've already got all of that taken away. The only thing left on the table on our motion for continuance really involves the production of the original documents that we wish to have a forensic examiner test for authenticity, because we've been claiming forgery on these. And if you don't mind, because it's a motion for continuance, I'm just going to straight go through O'Connor's, hit the description and why it's material, and I'm going to show the judge what it is. And then I'm going to briefly respond to one of the arguments of the opposing counsel, and then we're just going to pass the floor because I think this is very simple. So I'm going to try to share my screen, Your Honor, to show you what the notes are that we want to have the originals basically produced.
Is this set for today? This is a motion for continuance. It's not a motion.
Yeah, we have a motion.
Go ahead.
We have a motion for compel that's set for hearing this Monday. That's not the subject of today's hearing, Your Honor.
Right, but Your Honor, the reason that we need to extend fact discovery in this case is because the only thing we need to have continued is the continuance of fact. We've already did continued trial. So the only thing left on our motion for continuance is the continuance.
This case is set for trial on July 21st.
Yes, but a few days ago, Your Honor, at plaintiff's motion to quash the depositions, the court ordered us to, because we were demanding a jury trial, to agree upon a continued trial date, which we have, and we've put that as February 15th currently. We've also got in on the continuance of certain discovery. We've also got into continuance for the depositions of Jin-Suk Park and the corporate representative. So the only thing on the motion for continuance that we need to going forward is when you have a motion for continuance of fact discovery, you have to describe the discovery sought and its materiality. And so that's what we need to do. I completely understand plaintiff's position that we have a motion compel out on this on Monday, but a lot of this is going to overlap because a motion for continuance has to describe the discovery that we need, the procedure for the discovery, the substance of the discovery, its materiality, and why we couldn't, what our due diligence has been.
I don't agree with that at all. Motion for continuance doesn't need to do any of those things.
I'm just going straight from O'Connor's, Your Honor. It's just because I think the motion for continuance is just about the fact discovery that we need to go forward on this case, why we need a continuance of fact discovery. And it's just because of this one piece of documentation that we want produced. And the other side is objecting to producing it because they say fact discovery is closed. So the only way we can get these original documentations produced for us so we can examine their authenticity, which we have a right to do under TRE 1002, is they say fact discovery is closed and therefore we don't have to give you these documents. And so we're trying to get fact discovery extended just so we can analyze these documents for their authenticity. That's it.
All right, but we don't have to argue the merits of the motion to compel. Response on the extending the fact discovery?
Yes, Your Honor. Can I share my screen to show exhibits from my response? I'd like to go through it.
Okay.
I think it's important. Oh, it looks like participant screen sharing is disabled.
Let me see if I can turn that on. No. Okay, go ahead.
All right, just 1 second. There we go. All right, so as the defendant's counsel has noted, we have agreed with the defendant on the reset of the trial date to February 15th, 2021, and which is also going to accommodate the defendant's jury trial demand. And then we did list a few things we were able to agree to in the agreed scheduling order. And as the defendant's counsel has noted, the court is permitting the 2 depositions to occur, and we are getting those dates, and we'll be getting those depositions going. However, we object to the reset of any other deadlines that have already expired that were based on the original July 21st, 2020 trial date. And this is primarily the expert designation deadline and the reopening of discovery. Now, the plaintiffs, my clients, we filed our original sworn petition on October 7th, 2019. The promissory notes were attached to this petition. Now, the defendants filed their original answer on November 15th, 2019, and there was no mention there of forgery. Now, mind you, at this point, they had several weeks to review the promissory notes, and if the defendants believed that the signatures on them were forged, that was their golden opportunity to say that, but they did not. And in fact, and this is what I've pulled up here, Exhibit A of my response, which is an excerpt from the deposition of the defendant. And if we go here, I put on the screen the original petition at the deposition, and I asked him if he's seen it, and I asked him when he first saw it, and he said, when I was told that a lawsuit was filed is when I first saw the document. I asked him, do you recall when that was? He said, I don't remember. I said, do you remember if it was last year in 2019? He said, yes, I think so. Now, in January, the defendants served written discovery responses. I'm going to go here to the next exhibit, which is Exhibit B. It's their original responses to the request for disclosure. And if you look here, this is what's highlighted is their description of their legal theories, and they say the parties agree that defendants would not be liable for any outcomes. Defendants performed all conditions precedent. Plaintiffs knowingly and recklessly made false and important representations to defendants. Please see original answer and affirmative defenses. Here, there's, again, no mention of forgery. I'm going to go here to the Exhibit C, which is their interrogatory responses. Those were also filed in January 2020, and I won't belabor going through every single one, but there is no reference here in these responses to forgeries. Now, at this point, Your Honor, defendants and their counsel, they've seen the notes and had them for at least 2 months at this point. No mention of forgery. Now, under our original trial schedule, March 22nd, 2020 was the deadline to designate experts in this action. The deadline came and went without any designation of experts, although at this point, the defendants had seen and had the notes for about 4 months now. And on May 7th, 2020, defendants finally served their own discovery, which is important on a separate note that the defendants didn't really do anything in this case until May 7th, when they finally served this written discovery. If we go here to Exhibit E, this is their request for production. And request for production number 1 says all documents relating to any contracts or agreements, whether written or oral, entered between you and the defendant. The point here is that they didn't even request original inked promissory notes. But probably the critical thing is that on May 22nd, 2020, and I'm going to go here to Exhibit E, and this is an email that's from a defendant's counsel, Mr. Rowland, to the mediators coordinator, who's Karen James, and myself. And this email says, our firm has just had a meeting with our clients and their interpreter. It has come to our attention that significant fraud has occurred in this case. It is likely that we will have to employ a forensic document examiner once plaintiffs produce original documentation. So 5 days after that, that's when the defendants filed this very motion. And it's the first time that they mentioned anything about forgery to the court. But even then, Your Honor, if you go to Exhibit F, this is defendants sort of supplementation to their a request for disclosure response. And I've again highlighted the paragraph where they talk about the legal theories, and there is still no mention of forgery.
Your Honor.
Finally, Your Honor, forgery was officially in the case for the first time on the very last day of discovery, which was June 19, 2020, when defendants amended their answer to add a forgery defense and counterclaim. So, Your Honor, what our position is that once you first see a document that you believe you didn't sign, you'd notice it right away. Even if you couldn't right away, certainly you could in 2 months. And certainly you'd put it in your written discovery responses. And certainly you let the deadline to designate experts pass without designating an expert. But the fact is, by admission by defendant's counsel, the first time this came up was when defendant Na came to visit defendant's counsel on May 22nd, 2020, more than 6 months after the original answer was filed, and claimed forgery. So either the defendants knew they had a forgery claim and they sat on it, or it's a recent fabrication. It has to be one of the two. You don't just see pivotal documents in the case and say nothing about forgery for 6 months, and now all of a sudden you want to claim forgery. It doesn't make any sense. There is no good faith reason for defendants to not have raised this defense and claim when they first answered on November 15, 2019, or at least early on in the litigation when defendants responded to plaintiff's written discovery, especially considering the promissory notes were attached to the sworn petition. And defendant Na has testified under oath that he reviewed the petition, and thus he reviewed the promissory notes in 2019. This is why, Your Honor.
All right, Mr. Rowland, what's your response?
All right. Well, I was going to address much of this in our intro. A lot of the promissory notes that they're talking about, I'd like to show the court. And there's a very, very, very good reason we didn't talk about this exactly the way we are doing so until later. And it's because our client found and supplemented discovery because they found all these new notes that were sent earlier. And I would like to show the court them. And this is the only thing we want on the authenticity tested of. But before I get to that, I would just say there's some factually and legally erroneous parts of plaintiff's claims. First of all, just regarding forgery and basically our answer, from day one, we answered fraud. We said fraud is an affirmative defense from the very, very get-go in this case. And this is from the very, very beginning. Forgery is a species of the affirmative defense of fraud. Forgery in and of itself is not an affirmative defense. In fact, we didn't even have to plead fraud because forgery actually extinguishes an essential element of their claim, which is breach of contract. You can't have meaning of the minds or intent to be bound if there's forged documents involved. The signatures are not Mr. Na's, therefore there's no intent to be bound in terms of offer and acceptance. So this whole issue of when we brought up forgery is just a complete red herring because an essential element of their claim in which they have the proof, we actually did affirmatively plead fraud from the very beginning, and we would never have had to plead forgery at all at any time in this because it's merely a species or an aspect of fraud. That's one. And why did we not bring this up earlier? Well, we'll let you know. So if I'm going to share my screen right now, and we will show you what everything the plaintiff's counsel is talking about and why we brought this up to Karen, you're going to see the email that I sent that's 100% true. I did send that email, and here's why. We found and supplemented, if you can see, two notes that were sent to us and we signed in 2018. We were told to sign these notes because Mr. Park said, I need to show them to my wife and then I'm going to rip them up. Apparently he did so because how many years later they attached different notes to the original petition. So if you can see my screen, Your Honor, on the left side, we have the notes that plaintiffs attached to their original petition. On the right side, we have the 2018 notes that they faxed to us that we signed. We signed the notes on the right. We admit to signing that. Mr. Na's an old man. When he saw the original promissory notes, and this is why we included fraud, he said, this looks different. I don't remember exactly signing this. I signed certain things like this, but it doesn't seem right. It's not right. And plus, that doesn't even look like my signature. So finally, throughout discovery, Mrs. Na, when cleaning up the house, found these notes that the plaintiffs faxed to them. And throughout, you can even look at how different they are. They created new notes to try to attach their original petition, and they contain entirely different signatures. So these are supposed to be the same notes, or I don't know what. But what our contention is, and our clients told us in this meeting with the translator, they had to bring a Korean translator, was on each of these notes. This one, that note right here that I'm pointing to, entirely different signature than over here. This is always Mr. Na's signature, and they're radically different. On the left, same thing on the 50,000 one, radically different, and I can show you right here, radically different. So everything that the fact ways, we didn't get these notes from our clients because they didn't find these things from 2018. But as soon as we did, we supplemented our discovery, and it shows very well and clearly how the signatures are different. Now, the only one signature, the only note that plaintiffs attached to their original petition that actually contains the right signature of our client, he says, is this one. It's the merchandise note. But he says that when he signed it, this 171 language that you're looking at is not here. And yet, when we deposed the plaintiff, he said that no language and no writing has ever been added after the signature. So this is the only note with the accurate signature. This is, however, it seems like there's a discrepancy because we're saying, hey, they added this 171 well after, and it seems like there's a date, but when we deposed him, he disagreed. So what we're saying is all these four notes beforehand that plaintiffs attached to their original petition, that's not the signature at all of Mr. Na. That's the signature of Mr. Na. I mean, it's consistent throughout. That's the signature. That's the signature. That's the real signature. Look what they tried to do. They recreated notes at the last second that are completely falsified and tried to put them into the court. And we didn't notice until we got the 2018 notes. And that's when I told Karen James at Burden, and that's when I sent it to plaintiff's counsel, look, we have really great proof of forgery and fraud. So we've been saying fraud from day one. We asked them before fact discovery closed to produce these documents, and they wouldn't do it. They just said they didn't think they had to. They gave you all the reasons. They just told the court on why they didn't think they had to. But this is our position of, listen, there's obvious fraud here. We couldn't get this done earlier because there's coronavirus. Our office was shut down for 2 weeks. As soon as our office wasn't shut down, we were allowed to have the NAS come in with their translator to basically show us this. We then, before fact discovery closed, asked for all those documents. They refused. And now we're here. And that's when we did motions for continuance and motions to compel. So we think it's so easy. We only ask for one thing. In this case, all we want going forward before February, when the case is going to be heard for trial, we just want a forensic examiner to test the authenticity of these notes because they look like blatant frauds. And if we get that, we're happy. That's all we want. And the only reason we didn't get this done earlier is because our office was closed due to COVID, and Mrs. Na didn't find this 2018 fax they sent all the other time ago. And the only reason the other side didn't produce these documents was because they ripped them up and had to create new forged ones. So, Your Honor, we think this is a much to do about nothing. We think that basically, I'm going to show the Texas rules of evidence because it's pretty obvious that we should be able to get these. it says, all right, an original writing or recording or photograph is required in order to prove its content unless these rules require otherwise. So it goes to the admissibility of duplicates, which they think they can do. A duplicate is admissible to the same extent as an original unless a question is raised about the original's authenticity or the circumstance make it unfair to admit the duplicate. That's all we're talking about, Your Honor. We just want to get the first one tested. If it's a forgery, it's a forgery, and that's what we need.
All right, response?
Yes, Your Honor, our client's position is that there were several notes that were re-executed, but they were re-executed specifically at the request of the defendant, who wanted them to be attached as a lien to a property that defendants owned. We don't dispute that they were recreated. They were recreated at the request of the defendants. Secondly, none of this has ever come up in a document request. You have to request, if you want to request original ink notes, then request it. Secondly, finally, when the defendant's counsel and I had a discussion, they informally asked us about the original ink notes, they didn't even propose any sort of procedural safeguards. They just said, give us the notes, hand us the notes. They didn't say, well, we want you to hand this note to this person and they'll hold it for 2 weeks or however long they need it and then return it back. They just said, we want the original ink notes, and very late in the discovery process.
Your Honor, if I can respond, we are totally understanding. I personally don't want to even touch the note. I don't want it in our office. If that was, we've tried to be very clear for this. We only want it to go to a forensic examiner. I personally don't ever want to look or touch the note. I mean, I don't need it. We just want this to be tested for its authenticity. If that's why they're not giving it over to us, we can solve this right now. Because, like I said, I don't want to touch the note. We just want to give it straight to.
Can I respond to that? We won't be able to work this out. Can I respond to that, Your Honor?
Sure.
We would agree. If the court is inclined to allow the defendants to designate an expert, despite the fact that the deadline has since passed, we would agree to, our clients would agree to give the original wedding notes to an examiner for a limited duration of time. But we don't think that any other discovery needs to be reopened. And it sounds like defendants not suggesting any other discovery be reopened.
Well, sounds great. It sounds like we have an agreement that discovery will be open just so each side can hire and use a forensic examiner. And so we just need to get dates when that's going to be done, and that the original documents will be provided to each of the forensic examiners. So when do y'all want to get that done?
We're ready to get that done as soon as possible. If Mr. Shahari wishes to mutually agree to get that done, I can do that. We're very amenable and ready to go.
Yeah, I think we'll have to discuss the dates with Mr. Williams. Just we'll have to gather stuff up and come up with a schedule.
Why don't y'all do this? Why don't you get we have a hearing set on Monday, right? So if you can, let's go ahead and get me a scheduling order that complies with all of this. Usually what we would do, what I would suggest that this is in order, is maybe give Mr. Rowland 30 days or 20 or maybe 2 weeks to designate an expert and provide the document to that expert. And then Mr. Shadari, you may want to have an expert yourself.
Right.
So give you additional time after that, maybe 30 days after the document inspection occurs, whatever that is. You can build in whatever deadlines you want. You have plenty of time. But just make sure that it's all included, and then make it clear that there's no other experts to be designated and no other fact discovery to be conducted, and just include that all in the order. If you can, try to get that to me by 3 o'clock today, the proposed order, and send that to my court coordinator.
All right, thank you, Your Honor.
Anything else, guys?
That's everything.
That's everything.
All right, you guys be safe.
You as well.
You too. Thank you.
All right, bye-bye. Okay, I think we have a Miss Dallas. Miss Hundley, is your opposing counsel here? Are y'all, can y'all hear me, Miss Dallas, Miss Hundley?
I can't, Your Honor. I was scrolling through, and I don't think I see Mr. Dilbeck.
Is that Jake?
It is. Sorry about that. That's a remnant from our online school. I have to figure out how to fix
Are you
that.
Mr. Gilbeck?
Yes.
Okay. Y'all are here on the scheduling conference, is that right?
Yes.
That's
Okay.
correct.
And kind of tell me what's going on. You guys need to set this for trial.
It's fairly early in the case, Your Honor. We've just got answers in the last month or so, give or take. We've got some informal discovery going on, so we don't have any real plans for any major discovery. We've talked about just exchanging documents and having some settlement discussions early, but not much else is going on in the case just yet.
When do y'all want to set this for trial? How many depositions are you going to need? That kind of stuff. If it doesn't settle.
I would say probably 3 to 5 depositions. I would say maybe a spring 2021 trial setting would probably be appropriate, but we haven't discussed that between counsel yet. So I'm open for suggestions if they disagree.
Is this going to be a jury trial?
Yes.
Ms. Hundley or Ms. Dallas?
Your Honor, I think that we would be agreeable to that. I think spring 2021, I agree, is probably a good time to aim for. And I do think that between us, we should be able to reach an agreed date.
We're going to set the date now, so that's what the purpose of this hearing is. So what I was thinking maybe, how about sometime in late May or June? I mean, we're going to have, I anticipate at some point, an avalanche of cases because we haven't had jury trials in so many months, and there's not going to be any for a while. And so I would say we're pretty busy, or not more than pretty busy. We are swamped in the spring. So we're going to probably set you guys sometime in the summer. Why don't you guys get your calendars out as and I believe your national counsel, is that Mr. Feinberg? Is he your national counsel? Mr. Steffi, are you here on what are you here for, sir? Oh, you're not here for this. You're for the Olga case. So when would y'all like to get this set?
I could be pretty flexible for June 2021.
I'm looking at the calendar now, and Matt, you might want to correct me if I'm wrong, but I don't think that we have anything in June that would make this a problem.
Your Honor, if I may address the court, the only date in June 2021 that would not be available to us, or the only dates, are June 23, 24, and 25.
Okay. How long will this take to try, do you think?
3 to 5, Matt?
3 to 5 days?
If that.
I would say 3 maximum, but we could say 4 to be safe.
Why don't we set it the first week of June to make sure you don't conflict with this other scheduling conflict? How does that sound?
That's fine, Judge.
Yes, Your Honor, that looks fine for me as well.
Ms. Hundley, Ms. Dallas?
Yes, Your Honor, that's good.
So we'll set this the first Tuesday of June in 2021. Is there any other schedule? We also can discuss anything involving the scheduling order, or do you guys just want to work that out?
I think we can work that out, Your Honor.
I agree.
Okay, we'll go ahead and set it for trial the first Tuesday in June of 2021. Go ahead and get us an agreed scheduling order at your convenience, and you guys have a great day. Okay.
Your Honor, if I may, would it be possible to take up the Pro Hoc Vice motion that's just been entered on the docket a couple of days ago?
Sure. Is there any objection to it?
No, it's not opposed.
Rhonda, go ahead and print that out, put that on my chair, and I'll sign it on Sunday. And just put a note on it, Rhonda, that it's agreed to. Okay. Anything else, guys?
That is
No,
it.
Your Honor.
No,
Thank
Your
you
Honor.
very
Thank
much,
you.
Thank you, Judge.
Thank
All
you.
right, you guys be safe out there, and we'll talk to you soon, okay?
Thank you very much.
Thank you.
All right, I'm going to turn off YouTube for right now, and I'm going to take a quick break.